Hello, and thank you for joining us for the Ask Andrew Show, Canada's first Facebook Live streaming family law question and answer show. My name is Andrew Feldstein, and I'm the principal of Feldstein Family Law Group. We have offices in Markham, Vaughan, Oakville, and Mississauga, and both myself and our entire team of lawyers practice exclusively in the area of family law. Today, we are joined by one of our senior associates, Mr. Jeff Hart. Welcome to the show again, Jeff.
Thank you, Andrew. It's a real pleasure to be here.
And it's a pleasure to have you. Today's show, I think, is a fascinating topic. It's retirement and spousal support. Lately, I've been seeing more clients who have concerns about when they can retire, what the financial impact will be on retirement, and some even come in after they've retired and they have issues arising from that. So can you share with us some recent trends you have witnessed in your practice regarding retirement on spousal support?
Sure. I can tell you that I had a recent file, and a judge said something really interesting to me that maybe you can tell me if you think it's a trend, Andrew, because you've been doing this longer than I have. But it was an odd sort of thing that His Honor had said, and what he effectively said to me was, in this matter, entitlement was based on a contractual relationship. It was a separation agreement that the parties had drafted up, and so I was looking to get the judge's opinion on, if there's been a huge post-separation increase in income, how are we going to treat that, given that it really wasn't contemplated in the agreement. And the judge more or less said to me that a principled basis for looking at that and dealing with that would be to look at the expectations of the parties at the time that the agreement was drafted, and sort of not just what they expected, but what they actually agreed to, and sort of work from that. Don't just sort of have a de novo review, so to speak, or just throw out the agreement. And that was something new to me, Andrew. I've never had a judge specifically tell me that the circumstances around the negotiation of the agreement itself would sort of temper or prevent, in this case, a much larger, what I understood and what I expected to be a much larger sort of retroactive payout. Have you ever seen anything like that yourself in files you've had?
Well, I've had a number of cases in my experience that deal with post-separation increases in income. And I think from the legal test, the starting point is whether or not there was compensatory support as part of the claim. For our viewers, compensatory support is the claim where one spouse is paying spouse support in part because they're compensating the other spouse. A typical case for compensatory support is someone gave up a career and stayed home for 20 years raising the children, and now they're 53 years old and they don't have any employable skills. So in that case, there's compensatory support. And the case law will typically say, from my review of it, that when there's compensatory support, the post-separation increase in income will be directly applicable. There's some case law that deals with a multiple prong test that deals with post-separation increases in support. And part of it talks about what was the plan? Was it the same career? Was it the same occupation? Was it just increases? But the first and foremost place, was there compensatory support? If there wasn't, you're in a much better place to resist than if there was. And I think part of the thought process maybe is what's built into the agreement. Jeff, you probably hear me when I'm teaching the juniors on a number of occasions. I talk about putting in separation agreements, what the logic of a certain deal is. If you're doing something that seems to be out of the ordinary, shall we say, what did the parties know at the time? So was that a case where, you think about, we talk about for spousal support, the test of material change in circumstance, and was the material change foreseeable or wasn't it foreseeable? So I'll give an example. If I'm a commission-based employee and I've been working on a deal with a very large buyer that takes a 2-year sales cycle, well, what was the plan that was going to happen if that deal came to fruition? How was that sale going to be included in my income? Was that contemplated in the agreement versus it's 10 years later and I just got some windfall gain of income that's a one-off? So I think there's a lot of questions. I don't necessarily think it's wrong to look at what was contemplated in the agreement, but I do think that whether it was compensatory or not was a key element. I don't know. What do you think about what I'm saying?
Oh, it's absolutely, and I know that compensatory really drives it as far as looking back, because if you're doing if you're looking at a retro award, whether or not there's been a post-separation increase in income, I mean, compensatory is the one that will get the judge's attention in my experience anyway. I mean, if it's if it's a lifestyle, if it's more of a non-compensatory lifestyle claim, they'll sort of turn the tables and look at you and say, well, what's your client done to help themselves out? Nearly as much as they're going to ask about what the other side's ability to pay is. In the file that I recently talked about, it was just it seemed that the judge sort of picked and chose some of the factors, but live and learn, live and learn. I'm not in that jurisdiction very often.
But one of the things you said is really interesting, is you said the judge picked some of the factors. And one of the things that I always say to people, when I'm going to court for them, I'm in essence selling their story and trying to fit it into the parameters of my understanding of the law. And judges will say, when I go to conferences, probably the same for you, that they start with doing what they think is right and making the law fit. So when I'm trying to sell my client's story, I'm trying to say, here's the right decision for you to make, Your Honor, and here's the reason why it's the right decision. And I have to give them that path to get there. And one of the biggest problems we have with retirement is understanding, because we start with the spousal support advisory guidelines, as you know very well about. And the spousal support advisory guidelines have a certain term. And perhaps I'll let you explain it. What does indefinite spousal support mean?
Oh, okay. So indefinite spousal support means that the payor will be paying effectively until the day they, die. I've not seen that too often, but that is the way sometimes it is interpreted by the court.
Well, sometimes it can be, but generally speaking, when we look at the spousal support advisory guidelines, it will say indefinite subject to a material change.
Right.
Because one of the questions the client will always say to us is, what if I get fired from my job? What if I get laid off? All legitimate questions. And if you have no income, that's a material change in circumstance. There may be a question about why you have no income, what you're doing to remedy it. And under the spousal support advisory guidelines, I think of it as two dreaded things if you're a payor. If you've been common law and married collectively for 20 years, you're paying indefinitely under the spousal support advisory guidelines. If your recipient's age on the date of separation plus the common law period and the marriage period put together as a formula add up to 65, you're indefinite as well. And if you're a payor, those are the two dreaded dates that you sort of, if you know about, you're looking at, you're thinking, oh my God, I'm hitting my 20th anniversary. I better be in a happy marriage, because if I don't end it now, I'm in real trouble financially. And I say that a little bit tongue in cheek, but it is a reality. And it's a question of, and I don't know if you see it, Jeff, I have clients that come in for an initial consultation, and when you do the math and you tell them they're on the hook for indefinite, can you imagine what that must feel like?
Yes, and I've yet to meet someone in that situation when I've given them that good news. Sarcasm. That was my attempt at humor. Sorry. That terrible news, frankly, from their perspective, that they're, and I say this a lot, you're a victim of your own success, sir. I am sorry to say it that way, but if you've done really well and you're a successful entrepreneur or a businessman, or you've worked at the same job for a long time and your income has increased, it's never a pleasant, frankly, it's never a pleasant conversation with those men and women when they're in that position. So what I do at least is to say, yes, I hear you. Yes, it's unfortunate. My opinion doesn't really matter. Maybe I think it's unfair. Maybe I think it's terrible. But here's the underpinnings of the spousal support guidelines. Here's the recent trends. Here's why judges think this. Here's the philosophy behind the spousal support advisory guidelines. And then they I don't know if they get any happier about the situation, but at least then they don't direct their ire at me.
And that's fair enough. And I've probably had a lot of people direct the ire at me, as you put it, because I can be very blunt. Some people like it and some people don't. But the interesting twist is the question I often get asked, does that mean I pay until the day I die? And my answer is, it depends. Maybe. Are you working until the day you die? In 2022 in Ontario, there's no mandatory retirement age. You may be working until you die. And if you're working until you die and you're going to be the payor because you make a lot more than your ex and you hit one of those parameters, yes, you will be paying until you die. But that's where the question of the show really comes in, is retirement. What happens to a person when they retire to their support obligation?
Well, just to steal something you just said, it depends. That's a phrase that lawyers are very, very used to saying and very used to hearing. Clients want more concrete advice usually, but I can see, I mean, it helps if you look at it like this, that retirement itself doesn't necessarily have to be a material change. It's not necessarily regarded as a material change. It usually accompanies the material change of a decrease in income. And so that's what I think anyway. I think that's why I personally began to associate retirement with material change, only because it's so often accompanied by a reduction in income. But retirement itself isn't necessarily a material change. I mean, if someone is, depending on your perspective, lucky or unlucky enough to be in a very strong financial position at retirement, it might not make a difference to the amount of support that they would have to pay. I mean, I've never yet encountered a situation like that where it just sort of the existing agreement or order just sort of continued on and it really didn't matter. But I mean, in theory, I suppose it could happen if someone has a very strong retirement package and investments, or has some sort of an annuity or something, some situation where income, there's going to be a continual income until they pass. I mean, that's certainly possible.
It opens up a whole plethora of issues from my vantage point, because a client can walk into my office and they may have a spousal support order or an agreement that could be 10 or 15 years old. And when you look at it, you may say to them, okay, you were paying, let's say, $3,000 a month in spousal support because 15 years ago you made $100,000. And in your last year of employment, you made $1 million. And you have the good fortune that your children grew up a long time ago, so child support wasn't in play. And you've actually been significantly underpaying spousal support for the last number of years. And if you're paying $3,000 a month and you're in the top marginal rate, that's going to be about $1,400 and change after tax it's costing you a month. So step one is doing an analysis of, you've had this great deal all these years, and a judge in their back of their mind is going to think, wow, this guy or this lady got away like a bandit. And then you have to say, taking your investment income, you got to look at it and say, okay, you may have this tremendous stock portfolio. It could be worth, let's say, $5 million at a 4% return on simple interest is an income of $200,000. And you may look at it and say, well, yeah, we could say you're going to retire, but in fact, if your retirement income is $200,000 and you think your former spouse is lucky to make $30,000 a year, I actually think your spouse support's going up, not down. So it's really important in these situations that you have to do an analysis before you even write to the other side and open the Pandora's box of what you may open. Now, that's an extreme case because not everybody's income goes up that much, hasn't given disclosure in years. But I've seen situations where things like that can happen. So you got to be really careful. Then we move down that to somebody says, well, I was a teacher. I get a pension that's going to cover 80% of my income. And I decided to go back and do some tutoring and some substitute teaching. And I'm actually making, when I put my pension in the mix and the other things, 110% of what I was making before I retired. And that can happen too. So they're not really retired because they're working part-time. And then we get down that other issue that we so often talk about is double dipping. And double dipping, I'll let Jeff explain what double dipping means.
Okay, thanks. So double dipping is when pension is treated as both a property to be divided in the property division. In most cases, there's property division, and also as an asset that generates income. So there are very few times when you're allowed to do that. Otherwise, if you treat the same thing as both property and income, you're getting twice the benefit, with hence the double dipping argument.
Now, what's fascinating is the Supreme Court of Canada has said you shouldn't do double dipping, but there are exceptions to the rule. So
Right.
you face this exception where if you have this great pension and the other person is hospitalized or in care, you may get stung with paying twice. That's an extreme example. But the other place where a lot of people make a mistake is if I worked as a teacher and my career was 25 years and I was married for 15 of those years, then it means what was equalized, very rough math, not done as a proper calculation, would be 60% of my pension because I earned 10 years of my pension outside of the marriage. That piece that I earned outside of the marriage is actually income that's available for support because that hasn't been double dipped. So now that payor who's thinking, I'm going to get this reduction because the pension is double dipping, finds out, no, 40% of your pension's going in. And on top of 40% of your pension, your substitute teaching's going in, your tutoring's going in. And they look at it and they say, I'm not getting much of a reduction at all, am I? And you're like, yeah, that's right. So there's all of these different scenarios that can play out. The hardest and the fastest one is somebody comes into our office and they say, whether I'm 60 years old, 65 years old, or 70 years old, because I don't know what the right age is anymore, because there isn't a specific age. It depends what occupation you're in. But they say, I'm done. I'm 70 years old. I've worked 50 years in this career. I want to be done. What would you say to that client?
I would say you're absolutely entitled. And I have said that to men and women in that situation. I mean, who am I to say that, let a judge tell them they have to keep working. That's the way I look at it. I mean, and obviously my argument is going to be, and to be fair, I mean, most judges would agree with that. Most, in my experience anyway, I mean, if you've got somebody in their late 60s or, closing in on 70 and let's say they're an entrepreneur and they've got their own business, and they could decide to retire. They could have retired whenever they wanted to. I mean, in theory, yeah. I mean, most judges understand that because most judges are closer to retirement age than not, depending on the judge. So it would be somewhat odd for them to take a position that they themselves would not want to see happen for themselves, I think.
Well, and when I look at it and somebody says I'm retiring and their investment income is really going to be their Canada Pension Plan, their CPP, their old age, probably some RSPs or maybe RSPs rolled into a LIRA, they're probably going to be okay to not have to pay support in that scenario. But the problem is we now live in a world where it's not always you're going at 120 on the 401 and then you're stopping and going to zero. Frequently, there's an off-ramp to doing consulting, maybe part-time work, and that plays into it. And the thing I've often said, when we get to negotiations is when it's really hard, because some clients want to negotiate within the agreement their retirement age is a hard and fast rule, where they want to say, I'm 65, I'm retiring, I shouldn't have to pay support, and I shouldn't have to entertain that argument about whether I should have retired or shouldn't have retired. I'll give our occupations as a lawyer. It's not like I think there's a preset age that all lawyers retire at. Some go into their 80s, some retire earlier. I was talking to one yesterday in his 50s who was talking about retiring. He's not divorced, so he doesn't have to worry about an ex-wife complaining that it was too early for him to retire. But the practical reality is, case law says you look at each case. And part of it is, what's their financial position? Where are they at? And where is the recipient at? And do you give notice to the recipient if you're planning on retiring? But in the case where they want to negotiate it, I often say to the client, well, let's try and get a retirement date. Because if I'm acting for the payor, I'm cognizant of the fact that my client may have a good chance of retiring at 65, but know that my client is the type of person that plans on working and wants to work. So you go to the other side and you say to them, you know what? will guarantee you, subject to inability to work, i.e. they get sick, i.e. they lose their job, but my client's prepared to say they're going to work to 67. But what you're going to get for that client working until 67 is if they work after 67, that's their money. And the other side will frequently say to me, well, why should we agree to that? And a lot of lawyers will say that. But I can also say to them, ask your client what they think of my client. Because my client may turn around and say, if I'm 65 and I pay 1 red cent to my former spouse, I'm retiring. And they'll say it really clearly.
Yep.
So you have the leverage of saying, we'll give you the extra 2 years you're going to get, or 3 years, whatever you negotiate, or 1 year. But in return, if my client wants to give up their years of relaxation, enjoyment, satisfaction with what they've created, they will only do that if it goes in their own pocket. Otherwise, they will retire. Sometimes that works, sometimes it doesn't, but it really isn't a game, because for a lot of people, it's the truth. They may want to work, but they're going to say, I'm 67 years old, I'm tired, I'm only doing that to get ahead. I'm not doing it because I'm giving maybe up to half of it to my former spouse. So there's a lot of different dynamics that can go into that negotiation, and somebody can really be playing with fire when they want to negotiate that. And I had one, Jeff, I was in front of a very well-known senior family court judge, and she said to me in court probably about a month ago that once you hit, if you're a pensionable employee, your retirement date under the pension, you're good to go, even if you're 61. I must admit I was a little surprised by that, but
Yeah.
but her view was once you get your full pension, that's when people are quitting these days, and that's perfectly reasonable to retire at that stage. Okay, that supports my claim, but the other side, that really works if you're going to do a negotiated lump sum payment up front, which is very rare. But the flip side of it is the person may go, they may not go. But I would say to the person who takes a lump sum, if you're taking the lump sum and they go work till 70, you need to appreciate they probably wouldn't have worked to 70 if they were still paying you.
That's it. Yeah.
And that's part of the dynamic. So there's a real negotiation strategy. And with a lot of people, the date of their retirement becomes a really important issue if spousal support's indefinite, because people, I think it's human nature to want to know you have a date where if you want to stop working, you can stop working. And I don't know if that's your feelings when you talk to your clients.
I certainly get the impression from most of my clients that are certainly late 40s and older than that it is almost to a man and to a woman that a retirement date is something they would like to put out there, so that even if it's not a hard and fast number, like this shall happen at this date, it's you put it out there, you make mention of it in the agreement, and then you provide, as you mentioned earlier, a notice period, like a long one, like a year or 18 months or something, so that the other side can ostensibly prepare for the day when the support either stops or is reduced to a trickle or whatever. And then it's more difficult for a recipient to say, well, I can't survive like this because I can't have the rug pulled out from under me financially. Well, you had a lot of time to, and I don't mean to sound like heartless or like I'm trying to turf these people out onto the street, but you do need to take a look at your own situation and make moves that you can do, that are reasonable in your own support. And if you're given enough time to do it, then generally you're expected to you don't have to be, nobody's expecting anybody to be Warren Buffett here, but just reasonable moves and prudent moves. And that's, I get that a lot from judges, that if you've done that as a recipient, and if you've been reasonable as a payor, in other words, saying, this is how long I'm prepared to pay you, and this is how much time you've got to sort of get your things set out. Judges find that the payor can usually retire. Of course he can retire, but he can retire comfortably without having to be afraid that as you say, half of whatever he's got is going to keep flowing into the pockets of the spouse. reasonableness is the watchword, and it's the word of the day. It's always, as you know, always the right word, always the right way to be, if you can help it, in front of every judge. And then once they see that you're being reasonable and you're taking the other side's position into account with your submissions or your position, then they're more apt to find either find a middle ground, or to find for you if your position is reasonable enough.
Well, I think it's interesting that you talk about reasonable position, because that's, I think, really important. That gets back to what I said at the beginning of the show. Do you have a good story to sell to a judge? And one of the things I always think of, a very well-known senior judge said to me, which is, what would have happened if the family was still together? So like he was explaining, at that time, the discussion was, somebody got laid off and they don't have a job. Spousal support goes down. What would happen to the family? They'd have to live leaner. That's reality. And if you were together as a family, I don't think many people would come home one day and say, guess what, honey? I retired today. I'm stopping work in 2 weeks. I can't imagine that's the greatest way to end up in one of our offices if you did that. But would there be a discussion? Would there be notice? Absolutely, there would be that discussion. That's human nature, to have that discussion with your spouse. Now, I'm not saying when you're former spouses, you're going to sit there having these discussions as if you're still husband and wife. You're not. But that's the whole point of reasonable behavior that you mentioned, which is, if you give 12 months or 18 months notice and you're of the right age that you're planning on retiring, I tend to think a judge is going to look at it and think that's reasonable. And that's probably in the back of their mind, well, that's a lot like what would happen if you were a married couple. You'd plan a year or two ahead of the retirement. And the other thing that really drives the words of what you said is reasonable is what another judge once said in court. Whenever he would see a motion to change, the first thing he would look at is the history of payment by the payor. And if he saw that the payor has a history of being late, has a history of making payments, has a history of bringing useless motions to reduce support, a history of not providing disclosure, there's a picture there. And that picture is, this person really doesn't want to pay support. And they're going to do everything they can not to pay support. And I heard him say that when I was in front of him as a young lawyer. And I took a really important message away with that. And the message I took is, your history of payments become critical when you actually want to bona fide make a change. Because they're going to look at that track record, and that track record is going to show you're a reasonable person. So if in the year 2005, I was ordered, or I entered into an agreement to pay a certain amount of support, and for 17 years, I faithfully paid that support in accordance with the agreement, and I was never late. And now I'm 65 years old and I'm giving 12 months notice that I retire, and I'm planning on not working in a year. There's a real statement there that, hey, I've played by the rules. I did everything that was expected of me. I paid like I should pay. I think that type of payor is going to be way more receptive to the retirement argument than the ones that, and we know them when we see them, Jeff, whether we act for them or against them, the game player. And you have some people realize that family responsibility doesn't take default steps until, I believe, you're 3 months in arrears. So sometimes you see this client who thinks, wow, I'm really smart because on the 90th day, I pay the 3 months of support every time.
Yeah.
But that's the kind of thing when you go to retire, a judge thinks, game player, what are they up to today?
Yeah.
So sometimes when you're a game player, it does come back. Jeff, I wanted to say thank you because for having you on the show. It's been a pleasure having you. I see that we're out of time. I really do appreciate you sharing your experience and knowledge. The next Ask Andrew show is on July 19th at our usual time of 12 noon. If you have any requests or ideas for future shows, please let us know by emailing us at info@feldsteinfamilylaw.com. And thank you for watching.